Thank you very much. I welcome everybody to the Justice Committee's 10th meeting of 2013. I ask everyone to switch off mobile phones and other electronic devices completely as they interfere with the broadcasting system, even when switched to silent. Received apologies from David McCletchy and I have John Lamont here as substituting. Item 1, decision to take business in private. We've been asked to decide whether to take 3 items in private today, and I'll go through them one at a time. Item 3 is consideration of our next steps following the evidence taken as part of the inquiry into the Title Petition Scotland Act 2003 is proposed as a private item to allow us to consider the evidence received and possible conclusions to draw, but I'm relaxed. My goodness, am I? If members feel they would prefer to have discussion in public. Are you agreeable to having it in private? Or public? Number 3, the decision to take item 3 in private or not?
If there's no good reason to take it in private, if you're relaxed about it, convener, maybe we should just take it.
I'm relaxed, but is everybody else relaxed is the problem? We're all relaxed, are we?
Possibly relaxed, but it's something that I wouldn't say in public. If it's in public.
Right, well, I don't want to inhibit. You see, this is the problem. I want you to say stuff.
Well, no, actually, it's to do with this. It's making too much of a deal of it, actually. It's to do with something in Angus's memo, which I didn't quite agree with, but maybe it's best if I talk to Angus about it at a suitable break.
John?
I'm happy for it.
You're happy, right. We'll just do that in public. So that one's item 4 is a continued consideration of research undertaken by the University of Dundee in relation to fatal road accidents. We've previously considered this issue in private as it relates to our work programme. MD, content to take this in private? Yes, thank you. Oh, sorry.
I'd quite like to take this one in public just because I think if we're discussing the reasons for pursuing or not, it would be good to have it on the record.
Yeah. I think if I see you nod, you wanted it in private. Graham, my feeling is that there's quite sensitive issues to be discussed here, and I want people to be free to discuss this, a very, very sensitive area, and I really feel it would be much better if we did this particular one in private. Can I have other views?
Are we able at the end of our private discussions to put something on the record about our deductions from that conversation?
We put in the minutes, we put something in the minutes, and we could discuss in private what we would like to put, if you like, into the minutes. Would that make?
I think Jenny's point about people will be interested in
it's
the way
certainly
forward is trying to ensure that the public are aware of how we've discussed this.
I think it's because we're taking it so seriously, and because it's such a sensitive area that's the reason, the only reason. It's not for any other reason whatsoever. And that we could put we could discuss then what we then put into the public as in our minutes. Would you be agreeable to that? Thank you. Item 5 is continued consideration of a draft report on the Public Bodies Act, Consent Memorandum for Public Bodies, AGTC Order 23. Are you agreeable that we take this in private? Okay, and the committee agreed last week to consider item 6 in private because it's a draft report. So I'll move on now to item 2, subordinate legislation. We have 6 negative instruments to consider this morning, 5 of which are the final tranche that come into effect in advance of the implementation of Police and Fire Reform Scotland Act 2012 plus one other. Can I just highlight to members that the Police Pensions Contributions Amendment Scotland Regulations 2013, SSI 2013/89, will be considered at next week's meeting, not today's as was originally intended. The Subordinate Legislation Committee is considering it this morning, so that's appropriate, I think. Turning to instruments, the first, the Police Service of Scotland Performance Regulations 2013, SSI 2013/61. Aims to transfer the existing procedures relating to the poor performance of constables below the rank of Assistant Chief Constable to the new single force, and establishes a new requirement on the SPA to establish procedures relating to poor performance of constables above the rank of Assistant Chief Constable. The Subordinate Legislation Committee raised a concern about defective drafting, breaking news, in relation to the appeals procedure, and the Scottish Government has undertaken to correct this. On that basis, do members have any comments to make in relation to SSI 2013/61? Please can I have something, a sound out of you.
I don't have any comments.
Thank you. Somebody spoke, so that's good. It's just that silence doesn't let me know whether we've agreed or disagreed. Are members content to make no recommendation in relation to this instrument? Thank you. The second, the Police Appeals Tribunal Scotland Rules 2013, SSI 2013/63, updates procedures in relation to appeals to reflect the provisions of the 2012 Act and the role of the SPA. The Subordinate Legislation Committee has drawn this instrument to the attention of the Parliament on the basis of an unexpected or unusual use of powers, the SLC felt that the constitution of police appeals tribunals should have been addressed through the relevant schedule to the Act, rather than through subordinate legislation. The Scottish Government argues that this is a supplementary provision and therefore there is various for making it in this way. Do members have any comments in relation to SSI 2013/63? No comments, thank you. Are members content to make no recommendation in relation to this instrument? Content. The third, the Scottish Police Authority Provision of Goods and Services Regulations 2013, SSI 2013/73, makes provision in relation to goods and services provided in connection with the SPA's functions. The Sublege Committee agreed to draw this instrument to the Parliament's attention on the basis that the form or meaning of the instrument could have been clearer. Further information is set out at page 25 of the paper, paper 1. Do members have any comments in relation to SSI 2013/73?
Yes.
Thank you. Jenny?
Convener, I have concerns. When we took evidence on the police and fire bill, I asked the Cabinet Secretary about backdoor privatisation and he assured me, I've read back in the official report, that there would be no backdoor privatisation from the result of the police and fire bill. But I think this statutory instrument throws open that possibility. And I wonder if we can perhaps invite the Cabinet Secretary to give evidence on this statutory instrument.
Right, before I say any further, this comes into force on the 1st of April, and this is the last opportunity for a member to seek to annul an instrument without things becoming very complicated. Hang on, I'm going to find out more.
We could write to the government and seek clarification.
I'll let the debate continue before we decide on the process. John, then Sandra, and then Graham.
Thank you, Convener. That's an interesting assertion by Jenny, and I just wonder if she would like to explain why she thinks that's the case. Because I think we heard unequivocal assurances that there would be no privatisation.
Well,
yes, no, I'll let you, of course, we've been challenged, I'll let you respond.
it seems to me that the statutory instrument lays out more possibilities. I mean, on the official report, I asked the Cabinet Secretary about terms of what could possibly be contracted out, and he talked about information technology services. But I think the statutory instrument lays open more possibilities, such as forensic services, if my reading of it is correct.
Sandra?
Thank you very much, Chair. John had raised one of the issues I was going to raise, but also under 28 in the first bullet point, it mentions that honour contracts with organisations which are already there on the 1st of April. So to allay Jenny's fears, I think that probably corrects that particular part. It's honouring existing contracts as on the 1st of April. I certainly didn't pick up anything about privatisation in CABSEC's reply.
I then have Graham, I think, next.
Yeah.
Yes, please. Yes.
I mean, I think the comment at paragraph 12 about the instrument could be clearer about specifying the types of persons and specifying the services as outlined in the schedule. And I had a read at the schedule, and it really is extremely vague and could be made to apply in many, many circumstances. I think it would be useful to get an additional comment from the Cabinet Secretary that confirm that what we're not going to do is get policy creep, even inadvertent, because there is a worry at this stage that we've already got problems in England and Wales in terms of forensic science, and in fact some parts of it are bankrupt. I don't think we would want to sneak that way by mistake.
To the OR. Roddy?
Just looking at Annex F to this statutory instrument, paragraphs 10 and F, I accept it's wider than information technology. It seems to be talking about vehicle maintenance primarily, inspection, testing, maintenance and repair of vehicles. So, yeah, okay, it's wider than information technology, but is that really causing us that concern?
Thank you. Anyone else wish to comment? Well, I think if given the situation, I think it would be useful if we indicate to the Cabinet, with your leave, that we write to the Cabinet Secretary indicating the nature of this exchange on the official report and ask him to comment and respond. You've put these exchanges down. I think that would take us forward. Thank you very much. So, in that basis, are you content to make no recommendation in relation to this instrument? Because we'll have a report, we'll have something back from the Minister. The fourth, the Police Service of Scotland Temporary Service Regulations 2013, SSI 2013/76, makes provision for temporary service out with the Police Service of Scotland. The Sublege Committee did not have any comments to make of this instrument. Do members have any comments to make in relation to this instrument? SSI 2013/76. You have no comments to make. Are members content to make no recommendation? Thank you. The fifth and final instrument that we must consider in advance of 1st April, the Police Federation Scotland Regulations 2013, SSI 2013/86, provides for the restructuring of the Police Federation in the context of the new single service. The Sublege Committee did not have any comments to make on this instrument. Do members have any comments to make? You have none. Are members content to make no recommendation? Our final instrument for consideration today, the Criminal Legal Aid Fixed Payment Scotland Amendment Regulations 2013, SSI 2013/92, provides that, for certain circumstances, a solicitor will no longer receive fixed payments for work done in connection with a grant of assistance by way of representation, but a payment based instead on the basis of time spent and work done. The Scottish Government has consulted with both the Scottish Legal Aid Board and the Law Society Scotland, and both are content with this proposal. The Sublege Committee did not have any comments to make this instrument. Do members have any comments to make in relation to the instrument? You have no comments to make. Are members content to make no recommendations in relation to this instrument? Are you awake? Yes, thank you very much. We now move on to item 3, which we are taking in public, inquiry into the effectiveness of the provisions of the Title and Conditions Scotland Act 2013. And the purpose of this item is to consider the main issues arising as part of our inquiry. Members will see that Spice has provided a short summary of the key issues. If I can just locate it. Now, if I'll just trail something before you start, I think you can tell me if you're content. Just, sorry?
I was going to request some information, that was all.
Shall I proceed, or what do you want?
You proceed.
Oh, very kind. How very kind. Very, 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 very kind. I think the committee has two main options here. Either we write to the Minister for Community Safety and Legal Affairs to ask for the Scottish Government's response to the issues raised during the inquiry, or do we feel that the issues are such that would be appropriate to report? So really it's just a matter of the form this takes. If we report to Parliament, do you want to do that now or wait until the Glasgow Factoring Commission has reported after 17th April? So that's really, first of all, what do you feel? Perhaps we should have the discussion first, and then we can decide whether or not we want just to write or a report and delay it. Yes, thank you.
With section 53 on its own, first of all, there seemed to be a fairly universal view that this section needs to be looked at, and then the recommendation from our academics was to refer it to the Scottish Law Commission. Do we as a committee have the power just to say, write to the Scottish Law Commission about it? And do we have to go through other processes to do that?
I think we would, well, it depends what form we take, but if we're doing a report, we make a recommendation that this be, you know, the comments, because we had no resolution from the two professors about section 53, you know.
Agreement that they thought the Scottish Law Commission should...
Yes, we did have that, but they both agreed it was pretty well rubbish, but one thought we should just delete entirely, another had not quite a solution to it. So I think it would be a matter to put in a recommendation that this be particularly referred to the Law Commission to resolve this issue.
But would we need to...
Can we do it direct, or would you have to do it by Parliament?
Yes, we can make the recommendation. We can't instruct, of course. It's up to the Law Commission whether or not they pick it up. And if you're talking about writing, then that would be a different matter. If we were writing to the Minister to say, you know, here's what we found, what's your comments, and we would also be writing separately to the Law Commission, you know, recommend. It would be different if we took that route. If we do a report, of course, we would recommend that this be taken, the government seek the views of the Law Commission. That would be one of our routes. So maybe we should decide, maybe it's better to decide whether we want to write a report before we get into this, so we know how we resolve these matters.
When does the Factoring Commission report?
The Factoring Commission reports after 17th April. Sandra?
I mean, I would like to wait until the factoring report. I was going to ask for clarification, but you've given us clarification. I mean, I have concerns regarding the Land Tribunal and the accessibility of that to people to put forward their ideas, and not just developers. And also there was concern about the two-thirds majority also. Some factors seem to say that you don't need a two-thirds majority, and yet in the legislation it says you did. I would like to seek clarification on that as well. I take it we can put that in the report.
Well, this will ask you, the way you're talking, I think, my personal view is I'd like us to do a report, and I think it's also worth even at some point, if subject to you seeking a debate on the issues, there's enough, there's real issues about this legislation now, and there's certainly, I think, somebody's in the Bureau here, is there not slots, Alice, and there'll be slots for committee debates, and a short debate on our report would be quite useful, I think. Yes, Jenny, and then I'll come back to you, Roddy.
I wonder, Convener, in the evidence we took, it seemed like we were dealing with kind of two broadly separate issues, Section 53 and the property factoring issue. Could we write to the Law Commission asking them to look at Section 53, and could we write a report on the property factoring issue? Because I think that is the issue that people would be interested in debating in the Chamber.
I think we draw these all out in the recommendations on our report. You're highlighting the issues. The report is public. You know, the Law Commission might want to respond. It's certainly a recommendation of the Law Commission. But I think there's another issue here. It isn't just separating out Section 53. I thought land maintenance and ownership was a completely distinct issue for me from factoring as well. So there was, if you like, these two separate things, and then there was a particular problem with a particular section. You know, but there were two categories here which were very different in the issues they raised. I don't know if you feel the same. John?
Yeah, I agree with what's been said, Convener. I wonder, does the report lay out what we see as the frailties of the legislation, or is there scope for us to suggest perhaps some remedies or alternatives? Because certainly the community buyout option is one that appeals, but maybe we haven't heard enough about that. And COSLA have been discussing this. I passed something to the clerk yesterday that was drawn to my attention. So there is a growing debate around it, I think.
So, yeah, so I take it we're going down the route of a report, which is fine, yes.
I don't know what the evidence we would get from this commission, the Glasgow Factoring Commission, but is it feasible that the draft of a report could begin now, that we could write to the Minister to ask for some of these views? By the time we get a reply, we hopefully will have the Commission outcome, and we can then conclude the report taking account of these two additional elements. Is that too complex? So we could do all in their absence.
Yeah. I'm being advised, just in case anybody wonders why I'm leaning over all the time, that what we could do is report, have the Minister respond, and then maybe as an addendum to it, we could have the issues raised by the property factors. Would that be appropriate? If I used the wrong word, addendum, you're giving me a look.
No, you didn't incorporate the Factoring Commission stuff into it.
And then this is a problem for me. Can you speak here? No. It's a problem, you see. I've got to... The problem with doing this in public is I can't let the clerk speak in this. What we can do, let me start again, is do a report.
Yeah. And incorporate the Factoring Commission into that.
Incorporate the Factoring Commission into, but that means we'd have to delay it.
Not very much.
Not very much. Yes, delay it, have it published, we've settled a report, have the Minister respond, and then if we wish, have a debate. It sounds like a plan to me, yes. I'm quite happy now.
This question of the 2011 consultation, which is really about the land maintenance company issues, and seemed to have got kicked into the long grass. I see Mark Griffin has raised a general question for answer this week on that consultation, and I don't know what the Minister's going to be saying. One of my concerns is that there are, as you said, there are a variety of issues. I don't want us to be assumed that that was the only issue that we were talking about, and there are things like Section 53 that really could be kind of moved quite quickly without getting bogged down in the politics of that kind of consultation.
I think we've resolved that Section 53 stands alone as a particularly troublesome section, but in the overview of the Act there are two two lines here, and there's no doubt about that. There was an issue about, quite a legal issue actually, as I think you'll recall, about land maintenance when they also own the land, and whether in fact they have a legal right to enforce burdens on it. So that's a separate thing I felt from property factors who do not own the property, and therefore there were more pragmatic issues there than legal issues. Am I correct in understanding that? So we're going to, so if we were doing this, we'd have the sort of section 53 looking at it solidly on its own. Property factoring, land maintenance ownership, two separate sort of sections, as it were, on our report, distinguishing between the issues there. What do you want to say about the issues then? Section 53 we've dealt with, Law Commission. Let's have your views on this to resolve this, which is obviously very troublesome. Land maintenance, can I have your comments on land maintenance ownership? What kind of things are you? John.
Thank you, Convener. I've asked a number of questions about the role of local authorities and tried to understand at what point that changed. And the issue of bonds comes up. As I understand, following some inquiries yesterday, interest rates being as there are, a bond that would have anticipated to be 40 years worth of maintenance might run out much sooner now because there isn't the level of return on the sum invested by the local authority. I hope I've picked that up right. I think there's a potential connected with the planning permission and planning conditions that can be put on there, and indeed the encouragement of community ownership, because there are examples of where that happens and works very satisfactorily.
You want to comment on that particular issue, bonds, community ownership, Alison?
Right, I agree with John that we must highlight that there's a role here for local authorities to find a solution. They used to do it really well. We shouldn't assume that public open space only belongs to the people that live round about it. It helps to create communities, and therefore I think local authorities need to be drawn back into that role.
Colin?
Yeah, I agree with what's been said there. I mean, even to the point where there's an issue of this in my old council ward. I used to, well, I suppose I still do represent it, it's in my constituency, but it's a very, very similar thing. And it's actually I don't want to get into the actual thing itself, but it was dealing with the actual ownership, and it was actually a debate between who owned the ground. Is it still the developer, or is it the people who thought they had the deal to sort of carry on the maintenance? And it all gets very, very murky. Well, oddly enough, you would think so, but it's been subject to a very long-running legal case. But you have it's really murky ground, and I think anything that we could do to help tidy this sort of thing up would be really, really good for people who are suffering with this rather large area at the side of what is a nice estate.
Can I just, before I come to you, Sandra, can I first of all, do you want to put in this business of the legality of the position of the, question that, legality of land maintenance ownership to enforce, payment in terms of the operations, which I think was a reasonable discussion that the two academics had. And the issue of the practicalities as well. Sandra, you want to... It
was more the practicalities, because when I asked the academics last week just how feasible community buyout would be in this instance for landowning companies, they said, well, that's a good question, we don't know. So I think it's the community buyout issue as well. Is it feasible that people can do that? Because under law, they seem to say, well, it would be pretty difficult, in that respect, if there was even a willing buyer or a willing seller. I think that's something that we should be looking at in that. And the other one, obviously, I wanted to raise is Silhan Tribunal, which I'm very keen on.
Get to that.
Yes.
Can we just keep to that particular issue, because there were issues. It wasn't just about cutting the grass and pruning the shrubs. There was the maintenance, if I recall, of actual utilities. Does that not raise more complex issues about community buyout? You suddenly become liable for the pipes and the whatever running under it. Alison?
I think that, the two issues that need to be maintained are sometimes play equipment and SUDs, sustainable urban drainage systems, and those are really very important pieces of infrastructure, although they look nice and green. If they don't work, the whole community is going to be affected by that. So, yeah. It's important to highlight that as well.
Another issue, I was going to mention that, I think we've all had that in our areas where they are having to get indemnity, but also what was said about lawyers giving advice to, their clients when they're buying it. It certainly wasn't in statute that they had to give advice. The answer we got back from the academics was basically, well, they should, but it didn't say anything that they had to.
I'm not saying this because I was in practice, but you would be sued for negligence if you did not at least raise with your... I mean, they would have a very good case of a complaint if you did not draw the attention to the obligations that there would be there. And
there's a law commission said that, though.
Speaking of vested interests as member of the Faculty of Advocates, I think we're straying into professional negligence matters which we didn't take full evidence on, and I don't think we should have that in the report.
Well, we had nobody from the lawyers to rebut it, and I would do that with anybody, and I think some of us would be concerned, to start blame where we've not got other evidence.
It wasn't there in statute, and the answer we got back was basically it wasn't. It was just advice they were given. And that's in the minutes.
Yes, well, I better not say anything. Graham.
I think in connection with some of the comments that Sanders just made just now, that there were a number of comments from witnesses about a lack of culture in Scotland for the maintenance of property generally. And I think that that's one of the introductory remarks in this whole area, that we seem to have this view that we won't be responsible for maintaining common land. And I think the other bit, which connects to some of the comments that John made, is an acknowledgement these are expensive issues. And it might be easy enough to identify somebody to take responsibility for these issues, but there's a budget that needs to be identified because it's substantial costs. And that's obviously what has caused many of the frictions that we've noticed in evidence in the previous sessions.
That's a very good point. I think that's a good introduction to both sections, because the same applies to property factoring, because you're not going to pay to get the roof repaired if you're on the ground floor. We understand. So I think it's a very good overview about the culture and knowing what your obligations are on shared ownership or indeed in shared services.
There's also appeared to be a bit of a problem with identifying what is an acceptable level of service that came across, because you start off and everything's fine, everything's getting cut to, the grass is cut, the fences are mended, whatever other maintenance has to be done, and over a period of time the person who's doing the work actually starts easing off on some of the work, shall we say, so you get a lesser level of actual service. And that seemed to come across in the first evidence session that we had when we had Greenbelt here, because they seem to contradict themselves to a certain extent.
I think what you're saying actually is how the residents can call that to account, because if they simply withhold payment, they find that they're getting horrible letters and so on. And I think that was the issue.
It's a decision of what is an acceptable level of service at the beginning.
No dispute resolution there in the system at all at the moment.
Yeah, we're talking about that. Now, Jenny, sorry, you wanted to...
Just briefly, Convener, on the introductory point about the culture of, or lack of culture of maintenance of common property, the thing that worries me about this point, and I've seen it personally, I've seen it in casework, is that we don't have any proposed solutions to that. So to open up the report with that, perhaps we want to discuss as we write the report some proposed solutions, whether there should be more of a duty on conveyancing solicitors to explain that, whether, I don't know, or maybe we should take evidence on that. But it just seems to me to just say we need to improve the culture. How do we do that?
I think we're prepared to. I think we should perhaps mention that's been said in evidence how we change the culture. But I'm hesitant about when nobody's had a right of reply to something, whoever they are. Try not to sound as a former solicitor, but a right of reply to rebut anything that we took in evidence. It was a very brief, as I say, inquiry. So we have to be measured in a way. But I'm happy for it to be mentioned that this. Perhaps solicitors, would you feel solicitors should, I was going to say make more of a song and dance about it, but be very firmer perhaps with clients and say this is something you will continue to pay, rather than, as we know, because we had this evidence, and understandably people who are purchasing tend to be just thinking about their IKEA furniture and their curtains and the house, which is lovely, not wanting to face up perhaps the fact that they have a continuing payment. I understand that and be in the same position myself.
Well, I think, Convener, that's what Lionel Moss said, you know, that they're just very keen to get the keys. But, you know, putting the burden on solicitors for that education job was just the first thing that sprung to my mind. But what I'm saying is perhaps we should look further into what should be done to improve that. Because it is an important issue.
Yes, it is important, but we'll put that as a recommendation. And actually, I think the fact that we've done an inquiry into this and we'll have, we hope, a debate, and it should alert the public to the actual, you know, what lies ahead and the resolutions for them if they go into a property with common ownership or a land maintenance company that has ownership of the land. Not in a horrible way, because sometimes it's a good experience, but just this is what this entails. But I'm looking for, we know the problems, and now we're trying to look at, we've talked about education and so on, and we're wanting to look at some solutions. The bond was mentioned. Community ownership's been mentioned, though I think what Graham says about in a recession, frankly, whether you're looking for people to pay more for their house, so there's a bond, or whether you're looking to buy out, which is more money when they don't have it. We can say these, but appreciating the current background. What other items? 53 to the Law Commission. We recommend the Law Commission look at this. Are there any other recommendations you can see? Because I think we all know the problems. Rod.
Building on slightly from the factors, obviously the level of fee charge is not really covered by the 2011 Act. In fact, we could say that some mechanism to challenge the level of fee would be a step forward. Also, I think we're going to have to flag in the report somewhere, if we're moving on to community ownership or ownership generally, kind of ECHR implications for ownership of land, which obviously is one of the things that Greenbelt are very upset about, any suggestion that they might lose land. So it's going to have to be in the report somewhere.
Just expand on the ECHR point, Roddy.
You know, kind of about protection of, it's the protocol to Article 1, protection of ownership rights. That's a human right too. So we haven't really dwelt on it in any detail in our...
But we should flag it up.
Yeah.
Thank you very much. John, you were wanting to come in, and then John again.
I mean, my point's similar to Roddy's. I mean, I think Professors Rennie and Reid both suggested a possible solution might be where residents wanted to change management company. We needed to create some right for the change of ownership of that land as well, which doesn't currently exist. I think that was a possible solution that both professors agreed on. So I wonder if we can capture that in some way.
Thank you. John?
It was just a point of information regarding it, and I don't know if it's exactly the specific point, but the issue of ECHR and land ownership featured in the recent court case relating to an absentee laird in Harris who felt his human rights were being infringed, and the court made it very clear that the people of Harris have rights that take precedence over any absentee landlord. So there is a recent court case about that.
Yeah. Nice to put it on the record, but we never took evidence. Remember, reports are based on evidence, not your lovely thoughts and your background to things. Alison?
Yeah, and the way forward is I would like some recommendation in relation to new developments that are coming forward, that local authorities, the government encourages COSLA to find a way through this to take them back into the fold.
Enforceability, is somebody want? Sorry, you want to go in first?
The likely fact would be that you have locally elected members who are able to, you know, monitor what's happening.
I want to, if you want to have just general discussions, first go at it. But what about enforceability from the point of view of the residents? Have you any issues about the way that works just now, either enforceability or getting out of contracts?
Was that the issue? Was that the point that I was making about the whether there were title conditions which could be enforced, which both Professor Rennie and Reid, well, Professor Rennie was more robust on that, all right? Is that the point that you're...
No, another point I want to make is say they were enforceable, let's imagine, because they weren't completely agreed on that point about whether or not they did it. So let's take the either argument, which is, yes, they're enforceable. What do you do if they're enforceable? And you're supposed to, under the current system, remind me what we're supposed to do if you're in a residence. You've got to have a residence association. You've got to have a percentage of the vote to change your provider, to change who won't own the land. So, you know, if A owns the land and also is the management company and you want B to do it, it's not very enticing. Do you want to say something about that? Both the mechanism and the practicalities. Or we just want to say it's... Yep.
Couldn't we just flag up that, you know, the evidence we've had on the point? I mean, it gets quite technical. What are we proposing to say? I mean...
Well, I'm just saying, it seems to me that in the legislation apparently gives residents a process whereby if they're not happy with the land maintenance company, they can get short of them and put in another land maintenance company. It doesn't seem to me to be possible or work. So if it's supposed to allow them to do that and it doesn't, there's something slightly amiss with the legislation. So what I'm looking for you is, we know that that's the fact. What recommendations do you want to make to the government? Or the silence mean we didn't ken?
We'd like to clarify the route by which these decisions can be taken, including what does a majority mean? Is it 60% plus or is it 50% plus one?
So it's a two-thirds situation again, isn't it?
Yeah.
I think it's, you know...
Is it the same thing on property factoring? Because you know more about that. Or is it
Well,
the evidence?
it does say two-thirds, but some property factors have said, no, it just needs a majority. But I think if you ask anyone who's tried to change their factor, they'll say it's not as simple as just saying it's a majority. And it is very, you know, stipulated that you do have to have at least over 50%.
There should be clarity about these things.
Yes.
Yeah, so in the general run into the report, before we, if you like, have, and it's really, we'll have a look at this, a first run at it, into the property factor, separate the land maintenance in section 53, we have a general overview about the issues that you raised, people being unaware of an educational thing, the fact that it doesn't appear in either of these circumstances in the categories is terribly easy to change, and perhaps more so in land maintenance. You know, we have some general points to make. Would that be, that looks clear, and then we divide it into the two, and then section 53 on its own. Is that all right? Is that the kind of structure? I'm content if we just leave it. Graham?
One final proposal for a solution. There was mention about, quite naturally, we've rehearsed a bit about whether solicitors tell clients or otherwise, but clients are obviously concentrating on other issues. Could we encourage the government to create a higher profile within property schedules for responsibilities in relation to maintenance in connection with any house or other property that they're purchasing? I'm sure there'll be a mention of it, but it seems to be not sufficiently highlighted enough that they understand these responsibilities.
Yes, no.
Come back to the same point I made previously. I don't think we took enough evidence on that to really make those kind of recommendations. Obviously, I'm speaking...
Change the culture. And you're quite right, it shouldn't be merely for solicitors to be responsible for informing. If it's within the schedule, then it's obviously a duty on the purchaser to read these things properly.
I'm very uneasy because I don't know whether it's in schedules or not now. I'm really not a clue, and that's why it's not a good idea for us to say something. I mean, our discussion's on the record, but because we didn't ask about it, I don't know whether it's a requirement. I don't know, under the Sale of Goods or whatever act it is that you do, or...
I can't see the Law Society being very happy that we're dabbling in things and we didn't even ask the Law Society to comment on it. Yes.
So, having put it on the record...
A number of, you know, issues it was pure information. We're not going to be the blame game here, whether it's through the lawyers or whatever, but surely we could say something like we had evidence of there was poor information given to potential buyers. It could be in the home report, it could be estate agents are responsible for that. You know, surely we could put something like that in.
I really don't know if it's in the home. This is the problem. I don't want us to speculate. But can I just say we'll put something in the draft which deals with, you know, people being made more aware. And if we do have a debate, then at that stage it's open to raise all these issues and having perhaps pursued further on the basis of the report, or deal in... Colin, you're looking peeved.
No. No. I'll wait for the debating points to come along.
I'm running a bit late, so yes.
Just a final point on this, the 2/3 thing. The point that was made by the professors were that it only applies when the title deeds are silent. And I think we also heard, or I may have read that somewhere else, that for kind of, it would be fairly extraordinary for kind of modern property transactions not to have some kind of stipulated figure, probably 50% plus one in it. So when we're saying that we wanted further clarity, I'm not sure that we should overemphasise that.
I'm going to stop there. This was the first draft, and we've gone back to things. And as I say, basically, we can't say things we haven't taken evidence on it. That's the end of that. So we're now going to move into private session. Thank you all for your contributions, and we go on to item 4 in private. So I'll wait for the room to be cleared.